SJC-12858, Commonwealth v. Charles Bohigian.
Ms. Upperman, you may proceed.
Good morning, Justices, Mr. Chief Justice, and may it please the Court. My name is Erin Opperman, and I represent the appellant, Charles Bohigian. And though the appellant raises several claims, we are here primarily because the trial court erred when it denied Mr. Bohigian's motion to exclude blood alcohol level results taken from test on his blood that was forcibly taken without his consent and against his will in violation of GL Chapter 90, Section 24(1)(e).
Is there anything in that statute that says you can't get a warrant if consent is not given?
The statute is silent as to the word warrant or obtaining a search warrant. What the statute 24(1)(f) is not silent to is that such a test, if the person refuses to submit to a test, shall not be made. And I think looking to 24(1)(f) and 24(1)(e) is all this court really needs to do to determine that the lower court erred when it denied Mr. Bohigian's motion.
When you look at intent of the legislature, which we probably should, in the words, I get your argument that you have to look at F and E together, which have prohibitions in both. But usually when you deal with 1F, it's the blood draw alternative, right? So someone comes in, they're offered a breath test, and the police have to say, you could also go and get a blood draw, and the person, and typically they give them those rights, and the person says, well, I want a blood draw, and they say, well, here's a phone book, go find someone, and it doesn't happen. But if we look at why it was set up, isn't the purpose of the legislature in 1F was to give an alternative for a blood test, to test the reliability of the breath test device?
I don't believe that that was the intent of the legislature. I believe that the intent of the legislature with respect to Section 1F was to ensure that it was known that an individual under arrest for operating under the influence had the right to refuse a chemical test, whether that chemical test be a breath test or a blood test. And the language in the very beginning of 1F says, obviously discussing implied consent, that an individual shall be deemed to have consented to submit to a chemical test or analysis of his blood, breath, or blood. So I don't believe that Section 1F is something that provides an alternative. It is.
Wasn't it in a response to the opinion of the justices because they were concerned about the Fifth Amendment problem with the fact that the non-consent would be deemed incriminatory? Wasn't that what's driving the way this is phrased?
Section 1F was enacted prior to the opinion of the justices to the Senate.
Okay.
And that opinion dealt with a potential change that the general court was then considering to make admissible evidence that a defendant had refused to take a test. And I think that that particular desired change by the general court and seeking an opinion from this court on whether or not that would be constitutionally problematic animates the intent of the legislature repeatedly over the last 60 years to forbid forced blood draws of individuals suspected of operating under the influence at the hands of the government.
And just so we're clear, this is nothing to do with the Constitution, state or federal, and it only applies to OUI prosecution. So if there was a motor vehicle homicide, manslaughter, a blood test based on a search warrant would be permissible, right?
I don't necessarily agree with that.
Why
Obviously,
not? Why not?
In this case, Mr. Bohigian was charged with both operating under the influence under Section A and also under Section 24L, operating under the influence,
So,
serious
so
bodily injury.
tell-
So
tell
I
me-
will address
yeah,
those two particular
No,
charges.
but tell me why you won't concede that it wouldn't apply to a motor vehicle homicide or manslaughter.
I think that the arguments relative to motor vehicle homicide and manslaughter by operating under the influence are a little further removed than a prosecution under 24L. But I do believe
But
that in all of those,
doesn't the statute say in any prosecution for violation of offenses set out in A?
it does say that.
So isn't Justice Gaziano right, though? It's just limited to those set out in A, right?
I do not believe that's right. And the reason I do not believe that's right is because 24(1)E was enacted in 1967. That language was reconsidered, albeit the language regarding the requirement of actual consent prior to admissibility of any blood alcohol level tests was kept in place every time the court, the general court, reconsidered that statute. It was revisited in 1971, 1980,
But I don't
and
understand.
1992.
But if the language itself is expressly limited to offenses set out in A, why would it matter that what its timing is?
Because my point in pointing out the year that that statute was enacted is because, particularly with Section 24L, that was enacted well after 1967. When the legislature promulgated that specific language in any prosecution for a violation of paragraph A, those other statutes didn't exist. Granted, it would have been
Write a statute after that, and this statute only expressly applies to these others. Why would you need to deal with the issue?
I'm not sure I understand Your Honor's question.
This statute about this consent issue says it's limited to Section A. You say Section L is drafted afterwards, but why would anyone care about this because it's not referenced? They're not cross-referenced.
The beginning part of Section 24(1)E deals with the admissibility of results of a chemical test. It puts forth that a chemical test results are presumed to be reliable and presumed to be evidence of how intoxicated someone may or may not be. And what it in effect does is, in operating under the influence cases, or in cases where all the elements of operating under the influence need to be proved, it allows the prosecution to present the results of a blood alcohol test without an expert. It allows the prosecution to enjoy a presumption that a blood alcohol level between 0.05 and 0.08, that there's a presumptive, rebuttable inference that someone is intoxicated. It allows the prosecutor to receive jury instructions at the end of the trial that any blood alcohol level above 0.08 is evidence of a crime. If this court were to determine that Section 1E did not apply to other crimes, which required proof of each element of operating under the influence, not only would a defendant not enjoy the right of refusal and the right, or I guess, would not be able to require that he or she have consented prior to admissibility of that evidence, but the evidence wouldn't be admissible at all.
I get it. If that makes L complicated because that cross-references operating under the influence. But if this were just a vehicular manslaughter case that doesn't require proof of operating under the influence, why would we be dealing with this statute at all?
And I would only submit to the court that if the charge was motor vehicle homicide by operating under the influence, and it was necessary to convict an individual of that crime to prove each and every element of operating under the influence, that all of the presumptions and requirements found in Section 1E would also apply.
I guess I have a much more basic question. Do we really have anything to do with the discussion about consent when there's a neutral and detached magistrate who's determined that there's probable cause to take blood?
And by we, you mean this
Well,
court?
I just think that when the legislature is drafting something and dealing with consent in this area, that you have to contemplate that there's the ability, if there's probable cause, to go before a neutral and detached magistrate and get a warrant such that the whole issue of consent really doesn't come into play.
I would say that to adopt such an argument would be to completely ignore the statute entirely. And that's certainly not something that this court is inclined to do, to read a statute such that it has no purpose whatsoever.
Isn't the strange answer to that question is, because you can get a search warrant for anything, body cavity searches, right? And what we've
Period,
said,
yes.
what we've said a lot of times is the answer is a search warrant in all the CSLI cases and the like. But isn't the answer to Justice Chloe's question perhaps, yeah, you can get a search warrant and you can take the blood, but it's never going to be admissible
I think
by
that's
statute?
I think that's correct. I think that there are, when you're addressing a search warrant in this particular context, in the end, you're really just evaluating or contemplating two different statutes. You have 9024(1)E on the one hand, and you have the more general statute that governs search warrants, 276 Section 1.
But that goes back to what Justice Kafka was asking you, because in one hand, you're arguing this is statutory, strictly enforce the statute, and then you're saying, well, broadly construe the statute to eliminate it for all types of drunk driving types offenses, no matter what they are.
I am suggesting that this court should construe Section 1E to apply to Section 24L. And that's really the only other statute that's at issue in this particular case.
No, that's fair. That's what's before us, but as you well recognize, what we say in this case will have ramifications.
I do understand.
Right, and that's why we're asking these
Can
questions.
before you leave 24L, because that seems hard to me, because I understand 24L talks about operating under the influence, but it's not a 24A offense, right? And this whole statute begins by saying it applies only to 24A offenses, doesn't it?
And again, I think that in reality, though it's imperfect, the explanation is very likely that Section 1E was enacted well before Section 24L. If the legislature had intended for the presumptions regarding intoxication based on a blood alcohol level test, the admissibility of a blood alcohol level test without an expert presuming that it's admissible and relevant, that is really what the statute is initially about, that this test can be admitted and that there's a presumption that the jury will be instructed on that it is relevant to intoxication, the level of intoxication. And in the end, it's a chemical test. There is, usually in a situation like this, a prosecutor would have to admit an expert to explain what this test is, what it determines, why it's relevant to an element of the charge. But the statute itself allows the court to instruct the jury that they must presume that it's relevant to this particular thing, and that from this information they can determine that one of the elements of the crime is met. If that wasn't applicable to these other charges, but I will speak specifically to Section 24L, it would upend those prosecutions. And it makes sense that the presumptions, the inferences, and the rights that accompany those presumptions and inferences would apply in any case where each element of operating under the influence must be proved, because in the end, both parties benefit from the application of 1E to Section 24L.
I wonder, though, I'm still worried about the timing, because the opinion of the justices deals with this Fifth Amendment problem. And I understand there's going to be a Fifth Amendment problem whenever you deal with the failure to consent. But I'm not sure that applies in 24L. I'm not sure the same Fifth Amendment issues are raised there. Because I haven't thought it through, but neither side's briefed this either.
And
So-
I guess I don't see how they wouldn't apply. I think in the opinion of the justices to the Senate, this court, I don't know that it found that there would be a Fifth Amendment issue. I believe that what the problem was under Article 12, and that was that a defendant in Massachusetts certainly enjoys
And
a broader protection.
You're right, it's an Article 12, not a Fifth Amendment issue. I get it.
So I think refusal to conduct a test of this nature, which provides some insight into the thought process of the suspect, eventually the defendant, would always be an Article 12 issue, and it would apply in Section 24L, and in a much broader class of crimes where a defendant is asked to make a decision of whether they want to do something which they may believe would incriminate them. It's the same reason why a refusal to conduct field sobriety tests would not be admissible in any charging a crime that contains the elements of operating under the influence. I think that if the legislature did not want Section 1E to equally apply to 24L, which is primarily an operating under the influence crime, it really only contains an additional element of injury to another party, something unrelated to the considerations in the operating under the influence statute, that the legislature would have said so. And I do believe that this court could not say that it would allow a prosecutor in a prosecution for Section 24L to enjoy the presumptions and the assumed relevance of the blood alcohol level test if it did not also conclude that consent was required prior to admitting a test in that, a prosecution under that statute.
Okay, thank you.
Thank you.
Ms. Horan.
Good morning. May it please the court, Donna Marie Herron, Assistant District Attorney on behalf of the Commonwealth. The trial judge here properly denied the defendant's motion in limine to exclude the defendant's blood test results where the Commonwealth obtained the defendant's blood through a search warrant and not through consent. So therefore, 1E and F do not apply to this case.
If I can walk you through 24 1F1, do you agree that, well, is it your view that a search warrant can be used to obtain a breathalyzer?
Yes, I think a search warrant that can be used to obtain, yes, to
Okay,
force a defendant to take a breathalyzer test. I don't.
Where it says, if a person arrested refuses to submit to such test or analysis, having been informed that his license or permit to operate motor vehicles shall be suspended for a period of at least 180 days, no such test or analysis shall be made. How do you understand that language?
I understand that if you're going under consent, and the applied consent that applies when you drive in Massachusetts, you're implied to consent to all breathalyzers or blood tests. I take that as if a person refuses to consent, then no test shall be made. I don't see it as exclusive, mutually exclusive, saying if you can still get a search warrant, and I would suggest if you look through the cases throughout this court, Commonwealth versus Angie Bioni, Commonwealth v. Dennis, which recently came out of the appeals court, they all recognize that you can obtain a blood test through a search warrant, or you could obtain it through consent. There's two different avenues for which you can obtain a blood alcohol level. And it's been repeatedly held that you can obtain it through a search warrant. I asked you look at Commonwealth v. Blaze. I just think there's two separate avenues you can go through. And if you go through the applied consent, which is outlined in the statute, and if a defendant refuses and you don't get a search warrant, then it's not admissible. It's just two different avenues you can use to obtain.
Okay, well, let's discuss that avenue. So if it were to be, if the individual had consented, let's look to the top. Is it true that where it says provided further, that if there is to be consent, or if there's to be deemed consent, it has to be done at a medical facility, correct?
Yes.
And provided further that no person who is afflicted with hemophilia, diabetes, or any other condition requiring the use of anticoagulants shall be deemed to have consented to a withdrawal of blood. So do you agree that if there is to be consent, there first has to be a determination that the person does not have hemophilia, diabetes, or another condition requiring the use of anticoagulants?
If you go into consent, yes.
Okay. Now, so we don't permit somebody to consent to a blood test unless we know that the person does not have those conditions, correct?
Under consent, yes.
So the search warrant affidavit makes no reference to whether this particular individual is afflicted with hemophilia, diabetes, or any other condition requiring the use of anticoagulants, does it?
I don't believe the search warrant did, no, Your Honor.
So how can, if the law does not permit an individual to consent without such a determination, how can the law permit it to be done pursuant to a search warrant?
I'm a little bit confused with your question, but it says shall be deemed to have consented unless, it's talking about consent, implied consent.
But what the law is saying is that even, we're not going to allow you even to consent to it unless we know that if we take your blood, we're not going to be in a situation in which we're going to be causing you the risk of serious medical harm, correct? That's why the law, that's why they basically say we're not even going to allow you to consent unless we know that we're not going to be in a situation in which you're going to have a problem with having your blood coagulate.
Well, I understand that, Your Honor, but if you have a search warrant and go to a hospital and the medical personnel, which has to withdraw the blood, takes the blood, if there is an issue with that, I would believe that the hospital would then tell the officer, you're going to put the person's health at risk if you take the blood.
How is the hospital supposed to know that?
They're medical professionals, Your Honor. I would assume they would know if the defendant has a medical condition which would make it dangerous for them to withdraw their blood.
How are they to know that? Unless the person tells them. The medical records, the person may have had no previous medical history at that hospital.
But how is an officer supposed to know that, Your Honor, if the defendant doesn't consent and they don't tell the officer that they have this
Because
medical
the
condition?
law basically says we don't even allow you to consent unless the officer says, do you have hemophilia, diabetes, or any other condition requiring the use of anticoagulants? If the answer is yes, I have those conditions, we don't even allow you to consent.
I frankly have never seen a case of that in the consent form, Your Honor, but
I'm just reading the statute.
I understand
So I
that,
guess
Your Honor.
my point is, how can, if the law does not allow you to consent without being certain of these conditions, how can the law permit a magistrate to order it pursuant to a search warrant without having that same assurance?
I think the law allows it, Your Honor, because the case law has consistently held that there's two avenues you can go with: consent or search warrant. And with the search warrant, then you have a detached, neutral magistrate determining whether there's probable cause to obtain the blood, and allows you to do that. Whether this section, I would assume that a hospital personnel.
Well, you can't, I mean, you've been to a hospital. You know that the hospital records are not, unless you've been to that hospital or unless you're part of that hospital network, they're not necessarily going to have a record of who you are or what your medical conditions are.
My answer is going to stay the same, Your Honor.
I understand, but I mean, but you see it as a problem.
I understand. I can see that as a problem, but I think that my answer is still the same, that you can go under both avenues, either search warrant or consent.
Okay.
How would that play out if there were a grand jury request or a Levine hearing? Would the medical condition of the suspect become a factor in the hearing?
After the taking of the blood, Your Honor, I would assume.
Before.
Well, I don't think it's possible to have a hearing prior to taking a person's blood due to the exigency of the alcohol level in a blood.
Right, although didn't the U.S. Supreme Court say it was not accepting exigency with regard to blood alcohol
For
dissipation?
warrantless search,
Search.
they said they will not accept exigency in itself, but then in Levine, in the matter of Levine itself, it says for the purpose of testing immutable, I can't say the word right, characteristics, meaning not exigent characteristics, and this court in Miles further elaborated on Levine, saying that that is for when time is of the essence and it's a temporary condition, they allow for a search warrant without an evidentiary hearing due to the exigency nature. So here, given the blood alcohol level is a exigent circumstance with a warrant, they allow, because you have a detached neutral magistrate determining whether there's probable cause, it's not warrantless, they determine that a hearing would not be practical.
So in every, are you done? Sorry. So in every case, every ordinary OUI case, this whole statute can be avoided by just getting a warrant in every single case, right?
You could, yes.
So this whole jurisprudence we've developed is, everything can be avoided. And maybe that's just because of the opinion of the justice decision, because we're worried about the effective refusal of consent. But, so it just, from now on after this case, just, because there's always going to be probable cause, or most likely. So basically, you've gutted this statute.
I don't believe we've gutted the statute, Your Honor, and I believe, as in this case, the state police clearly believe that they could obtain a search warrant, and therefore, thus, in the past years, they could have, in every OUI case, obtained a search warrant. Whether they would do that or not, I would deem as not practical in every case, given the serious nature of the victim's injuries in this case. They determined that a search warrant was necessary, and I would say you look to the purpose of the statute, and this Commonwealth v. Richards out of this court recently, when looking at the statute as a whole. Now there, they were looking at the license revocation for refusal to take the BT, but they were looking at the statute as a whole and says that the statute is to effectuate the Commonwealth's interest in obtaining reliable, relevant evidence by inducing a drunk driver to take a breath test and promotes the safety of the highways to
Right,
remove.
But it's an elaborate working around the Article 12 problem. But you've solved it now by, get a search warrant. You don't have to worry about Article 12, because maybe you're right, but it just seems pretty dramatic. This statute can basically be eliminated. Just go to the magistrate every time you got an OUI case, and you'll get blood taken.
I believe through a search, we get numerous things. We issue search warrants numerous times because we don't have consent. That's
I guess
another.
the issue is what the statute says, because of course you can get a search warrant unless there's a prohibition. And so what I understand, the discussion we were having with counsel before was you could limit 24(1)E by saying this isn't a prosecution under paragraph A. But the problem you've got is if you go to 24(1)F, what the chief raised, he discussed the language about anticoagulants, but when we go further down, it says if the person arrested refuses, blah, 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 and then it says no such test or analysis shall be made, right?
Yes, and I interpret that if you go under the implied consent, that's a portion of the statute, this is what that's referring to. That when you drive on the highways in Massachusetts, you're implied to have consent. If you don't consent, then no test shall be made under the implied consent.
I understand your argument that this is just completely different than consent, just like if you're receiving medical treatment and within the course of the medical treatment there's blood taken, that it has nothing to do with consent. But it does raise the question that Justice Kafka was getting at. We have habitual drunk drivers who if they know anything, they know not to take the breathalyzer test.
Yes, Your Honor.
And there's a lot of public safety concerns about habitual drunk drivers who know not to provide the strongest evidence. Why is it that all these years that we've had this problem, sometimes you'll see somebody with 10, 15 priors, that no one ever went and got a search warrant before?
I just think it shows the police's discretion in this matter in that this was a particularly harrowing accident, which led to,
But that's my point. My point is there are really dangerous situations. I had a case right in front of me, an OUI 10th, and the person went right through the light, hit an ambulance, and people were really hurt. No one went and...
I believe they could have, Your Honor. Unfortunately, they did not, but I believe under...
I don't know how you're going to answer the question. It's not a fair question, but it's in Justice Kafka's question, like, why didn't this ever happen before? We've got this whole elaborate statute that allows not only refusal of a breathalyzer, but its inadmissibility. And, you know, here we are with a judicial response system, a warrant maybe moments away.
In my case research, I've never seen one under the search warrant, but as I've noted, they all mention you can get blood one or two ways, through a search warrant, and then the cases always talked about consent. For whatever reason, I don't know why this issue has never popped up until now, but it has, and I would suggest, based on the cases that I've cited in my brief, that it's clear that you can get a search warrant for blood, and you can get an involuntary.
Well, the cases aren't OUI cases that you're relying on, right?
No, they are. Dennis was an OUI case.
Dennis, give me the facts of Dennis.
Give me 1 second. Angiovoni, the 1981 was an OUI case, but they all talk about consent. They
Right.
go
But
on
you have-
to.
Right, no, we haven't dealt with this issue, though.
No, I've never seen a search warrant. They all say you can either get a search warrant or go consent, and then the remainder of the decision talks about consent.
Are you at all, say you don't win outright,
Okay.
and I'm not saying you won't, I just don't understand this yet, but what about the idea that it's limited to, this statute is limited to OUI offenses, and 24L or vehicular homicide case would be outside of that? Do you find that persuasive, or is it an all-or-nothing issue for you?
Well, I find persuasive when you're asking my sister is that she said 24A was done years ago, and then they made 24L. The fact that the legislator having 24A there didn't refer to 24A, EF in its statute, I think speaks volumes that that was not their intent. So I would suggest that their intent was clear if it was crafted after the 24A, E and F, that it doesn't specifically direct you to go back to that. I think it's clear what legislative intent was there.
So in the world you want us to create, or what you say the law permits, is that whenever there is somebody accused of being a drunk driver who refuses to take a breathalyzer or a drug test, you can go immediately seek a warrant and get a breathalyzer or a drug test.
Yes, Your Honor, through a search warrant.
And do you agree that that would be a fundamental change in terms of how, at least presently, the world seems to work?
I don't think it's a fundamental change, Your Honor. I believe.
Are you saying that police routinely are seeking search warrants for either?
No, they don't routinely,
blood
but
warrants
I think in
or
serious cases, as
breathalyzers?
in this one, they do. And they did.
This is the first time we've seen it. And in Angioni, was that a search warrant case? That's an older case.
Yeah, no, I have not found a search warrant case, but
Okay,
they
so
all
this is
went.
the first time we have a search warrant for either blood or...
Yes, that I could find in Massachusetts.
And with regard to a breathalyzer, can you understand the challenges of having a non-consensual breathalyzer?
I can appreciate that would be very difficult, Your Honor.
But doesn't the law seem to treat breathalyzers and blood tests the same, in that both are deemed to be consented to, although for a blood test, it's deemed consented to only if you have been brought to a medical facility and you are determined to not have a risk of coagulation. Both are treated the same under the law. Both are deemed to be consented to.
Yes, Your Honor.
So we should treat breathalyzers and blood tests to be the same.
Yes, under the law, I think they are, Your Honor. I appreciate the difficultness of forcing someone to take a breathalyzer test.
And so you view the language where it says no such test or analysis shall be made to simply be, I'm trying to figure out what you understand that language to mean.
Under implied consent, Your Honor, that if you don't consent, you cannot, under the implied consent, force someone to take a blood test, but I don't think that at all excludes being able to obtain a search warrant.
You say we shouldn't pluck that language out as a general prohibition. The language is only there because talking in general about implied consent.
Yes, Your Honor. Thank you.